To try terrorism cases, many have argued that the U.S. needs to use secret courts, military commissions, and other alternative justice systems. Human Rights First recently released a report that shows these systems are not necessary because the U.S. federal court system has already effectively processed 120 prominent terrorism cases.
The vast majority of these cases, over 90%, have resulted in convictions of at least one count against the individuals charged. We now have laws that prohibit and punish what is called material support for terrorism. With these laws, people can be prosecuted and put in prison for long periods of time, not on the basis of having planted the bomb, not on the basis of having killed 3,000 people, but simply on the basis of having agreed to commit a criminal act, taken one step toward commission of the criminal act, or even just for having provided some kind of material support to the completion of a terrorist act, even if it hasn't yet been completed. The thing people ask the most about is, what about on the battlefield? Are you going to expect soldiers, while the shooting is going on, to issue Miranda warnings, advise people of their right to counsel? That is also a mythological objection, because the fact is that in a battlefield situation, there is simply no obligation on the part of soldiers to issue Miranda warnings. Laws that are in place and the procedures that are in place in our courts are well suited to protect national security information. For example, there's the Classified Information Procedures Act, and it provides a number of mechanisms by which a court and the government can protect sensitive information from public disclosure while at the same time guaranteeing the right to fair trial. When it comes to finding terrorist suspects and making sure that they are held accountable for their crimes and they are taken out of circulation to prevent the harm that they want to cause, the best bet of doing that is through the criminal justice system.